Hi, Bill Hensel here again, your Mr. Walking Constitution out here on the San Francisco Peninsula, and an update on what I'm doing with a seemingly crazy idea with civil rights, which, as most of you know, who follow my videos, I take the position and can prove every bit of it that the 14th Amendment not only doesn't exist, it never did, and neither do civil rights. That said, I also came to the conclusion that for better or worse, 42 USC 1983 is about the only thing in the way of a quote unquote remedy that these courts today recognize. If that's true, then I've also concluded, in concert with the fact that we can prove that there are no sovereign independent states remaining that were admitted into this union. And you can learn all about this. Send me an email, uwinnincourt@gmail.com. I can dead bang prove all of it, including now some very recent acts of treason in the Supreme Court of the United States. More about that on an upcoming video. But that said, we take the position that when we show up, we convert what's an administrative tribunal into an Article 3 court, judicial court. This follows the rule back in the days in England where the court follows the king. And that's what we were and are, sovereign, de jure, just sanguineous, free white state citizens. And this very likely applies, at least to a limited extent, to inhabitants of states and even inhabitants of territories. We are not generally subject to the de facto national socialist government in my former hometown of Washington, D.C. That said, the court has ruled, and the Constitution itself, albeit not overtly, prescribes that the enactments of Congress have a strong presumption of constitutionality. Since we can now identify there are two separate body politics here, in the United States, us, the state citizens, and the others who are corporate, citizens who owe their birthright citizenship to Article 1 of the non-existent 14th War Amendment. And we take the position that 1983 has to be construed to include our common law actions when we show up. This includes most particularly malicious prosecution and trespass via armis, by force of arms, and this in a situation where none of these quote unquote official actors, aka perps, is going to have any qualified, if not outright, judicial immunity from our lawsuits the way I'm constructing them. They knew or should have known what they were doing. Most of them went to law school, they have an education, and if they didn't learn in 4 to 6 years of law school, they can bring a later suit against the law school for not teaching them. That's not a matter for you or I to be concerned about. But that said, this is a hell of a stage to get on. And not only that, everything we do has striking similarities in every setting you're going to find yourself in, whether that's family law, the child procurement syndicate, IRS, criminal law, traffic courts, you name it. It's all the same problem. They don't have jurisdiction. And in California, for example, everything they do is in the name of the people of the state of California, who are conspicuously undefined in the Constitution they think is currently in effect. That doesn't work. Where in the world is the quote unquote consent of the governed? Not there, among other things. So that said, my unique take on this, and I just read a case called Lawrence v. Scott, I believe, a civil rights case, very recent one, and it was called to my attention. I downloaded it when it was decided, but for some reason, I didn't take a look at it like I would normally do. And this one was a bizarre set of circumstances. You have a 6-3 decision with 3 of the conservatives dissenting, and you have Kavanaugh and Amy Coney Barrett on the other side. Very unusual. And reading this, and I admit I'm reading between the lines here. I am, and I'm doing it a bit more than maybe usual. but I've been at it 40 years, and I'm pretty damn good at doing it. And reading between the lines, I think the court is telling those, that understand things like I do and like I will teach you to understand, is they're prepared to move even more forward than they have over the course of the last 2 terms, when there are things coming out of that court that haven't occurred, in my view, in 90 years. The court is acting like an Article 3 court, which it is, a judicial court. And there's a lot of things going on behind the scenes between Biden and Congress, and the court's warning them in no uncertain terms, don't try to pack the court. It failed with FDR when you had much more of a Democratic majority. It's going to fail now. We're going to act like a judicial court and do our jobs, and the hell with you bastards. And behind the scenes, I think that's exactly what's playing out here. And that plays into our hands with these civil rights cases. And I'm doing it in such a way that they don't, at the moment at least, have to rule on the constitutionality of the 14th Amendment. I would love to see that happen. Been on the books 160 years, and I can't be the first person that's noticed all the BS that's going on with that, especially in the Reconstruction era. But I know it, and I know it a cappella, and I can beat as many attorneys as they want to bring up. Their attorneys, by the way, otherwise known as unregistered foreign agents of at least the City of London. And this is the power we have in our one case, because we get it decided on the record, especially by the Supreme Court. It puts the state bar out of business from Portland, Maine to Portland, Oregon, and good riddance. You brought it on yourself. This is what you get for committing acts of treason and being foreign agents with no standing in our judicial courts. So there's a lot to be said here, and I'm going to help you out and get going. And the good news here, by the way, for us, no statute of limitations on deceit, fraud, and treason, and none of those BS administrative remedies to exhaust. We have a right to a judicial court from day one, and had from day one in the original case that you were involved in, but in any of those settings I've mentioned before, and really all of them, because all these state courts are administrative tribunals. And the good news for us is that the Supreme Court and the Fifth Circuit in particular are at war with the administrative state. And that's what's going to get the checkbooks out when I sit down at the bargaining table with them, even if it's only a Zoom appearance. Because my a cappella knowledge of 200 years of American law, history, and Constitution is going to point out to them, guess what, people? We're the ones rolling the loaded dice now, just like it should be. So that said, send me an email, youwinnincourt@gmail.com for more information. Meanwhile, subscribe, like the videos, sign up, tell your friends. And the sooner we cut out all this divide and conquer BS they've been doing for 150 years, the sooner we get them off our backs. Thank you.